Good day.
Hello, what's your name?
John Michael Funch.
All right, Mr. Funch. The plea form that I have indicates that the defendant will be pleading to an added count to a retail fraud in the third degree, the 93-day offense, on a successful plea.
Quick legal note here. He's pleading to a reduced charge of retail fraud in the third degree. That means a misdemeanor, not a felony. Smart move, because it drops the heavier count completely.
Count one would be dismissed. That's the entire understanding of the.
That's correct, Your Honor.
May I have him sworn? Is that correct, Ms. Counsel?
Yeah, yes, sir. I'm just actually pulling up the plea form, but I'm not sure that's right.
It's okay. Let's have him sworn.
I believe you.
Raise your right hand. Do you solemnly swear the affirmative testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I sure do.
State your name.
John Michael Funch.
All right, sir, it is this court's understanding you're going to be pleading guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs.
Did you catch that? The fine isn't just $500. It can triple depending on the value of what you stole. So that $59 tire could have cost him way more than the upgrade was worth.
The fine could be increased 3 times the value of the property taken. If that's greater than $500, that would be your maximum fine. You understand that?
Yes, I do.
All right. And understanding all of that, you still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on March 5th, 2025 at the location of 3300 Carpenter Road in Pittsfield Township, Washington County, State of Michigan? What did you do at the Home Depot that makes you think that you're guilty?
This is wild. He admits he literally just swapped a cheaper tire for a more expensive one and walked out. Honest? Yes. Smart? Not even close. Audience, do you think he confessed too easily here?
I had a tire to return, and I kind of just returned it myself, and there was a $20 difference, the price, and I just walked out with the tire.
You had a tire?
A tire for my wheelbarrow.
Oh, okay.
It was dumb.
And so
He purchased a tire at $39.
Right.
It didn't fit, so he brought it back into the store. And rather than waiting and doing the exchange with the customer service, he selected a $59 tire.
is that all correct, sir?
It is, yes.
So, and then when you selected the new tire, you did that and you walked out without paying the
I did,
difference?
yes.
And you knew that's what you were doing at the time?
Yes, absolutely.
All right. You didn't have anybody's permission at Home Depot to do that, did you?
No, not at all.
And the item that you took out that was priced at the $59, that was an item that they had offered for sale?
They did, yes.
All right. Counsel, have I complied with the court rule? Well, sir, I do have to advise you that if between the time of the acceptance of this plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea. You understand that, sir?
Yes, won't happen again. Yes, I do.
And also, sir, any recommendation or evaluation by the court would no longer be entitled.
Yes,
The court would no longer be bound by you. Understand? Second, okay. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Okay, plea accepted. That means the deal is locked in, and now probation will investigate his background before sentencing. Basically, this is the court's way of saying, we're not done with you yet. And have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
October 22nd at 12 noon.
October 22nd, 2025, 12 noon. Sir, looks like you have some other issues here.
No?
Well, I'm not.
Oh, sure.
Mr. Allen.
You don't have no warrants.
No, I don't. Yeah,
Right, I've got 2 warrants, and I've got a warrant which this is an old case because it has a 97 case number on it, and it was transferred from our original case management system into the new one. I'm not sure why it appears the way that it does, but it's a civil case, but for whatever odd reason has a 5,000 10% bond on the case. And they issued the bench warrant. It was a Samuel Hall Jr. versus John Prince. I don't know why that, when I'm looking at the case, there may have been, oh, I know why. All right. There was a subpoena, and I'm having to piece it together, but there was a subpoena that was issued. You didn't appear to court. Ultimately, at least my procedure was there was a show cause and then a bench warrant because you didn't appear.
Does it show he was served though, the subpoena?
I'm not.
I didn't know that.
There was a point at which there was no service. I do see that on here, but then they filed a new subpoena. Discovery was filed, and at a later date, then the bench warrant was issued. So I have to assume that the bench warrant was issued. That was, although it's a 97 case, because I took over that docket, I'm listed actually as the judge of record.
Now here's where things really spiral. Out of nowhere, civil cases, old warrants, and missing records pop up. It's like a legal rabbit hole, and this guy just fell in head first.
In that case. But I would not be the one that would be handling it now. What I'm going to do in that case, because it's so old, on that one, I'm going to cancel the bench warrant. All right. And then I'll just indicate that they need to reset before Judge Barr, who's handling our civil docket. You have another civil case that's from 2020. And the plaintiff, and it's a civil matter, is a Susan Wiesel. I don't know if you know that person versus you. In that case, again, it appears the same thing, except in 2023, a debtor's exam was scheduled before Judge Barr. And on April 18th of 2023, you failed to appear for that debtor's exam. The judge issued a warrant.
Was notice returned or?
I have no idea. I'm just looking at the file or at the printout. I would suspect that if notice were returned and Judge Barr knew about that, he would not have issued a warrant. But a bench warrant was issued on that. a bench warrant for whatever odd reason, even though it was in April, was then issued October 10th of 2023, and it's gone through this year in February. The warrant was valid.
May I have case numbers? Because we don't have
Case number,
access.
I canceled the one,
Okay.
one case number, the one that there's a valid, let me just give you, one case number is 97-2C3143. That's the one that I canceled the warrant on. The other one is 2004 C0243. Both of them, it appears, come from small claims matters.
Your Honor, is there an address in the 243? I'm trying to make sure you got notice of all this.
In the 243, there's the address of Parker Road, but I don't know when the warrant and everything came through, whether or not that was, no, I'm sorry, it's not Parker Road. It's Outer Drive. It's the same address that I have on this case.
So I'm asking the court to not take him into custody, but
It's a valid warrant. You're going to address that before Judge Barr. That's his warrant that was issued on the civil case. It's a cash bond only warrant from his failure to appear for a debtor's exam.
But, Your Honor, I'll be brief. As the court knows, we don't have access to JIS. Usually we'll run our clients' names through JIS and have the benefit of at least alerting our clients to warrants.
Right.
Without access to JIS, I interviewed him in the court. I interviewed him in the interview room. He wasn't aware of any warrants. That's why I was asking about the addresses and whether he had properly been served the subpoenas or served with notice of better hearings. And so because I don't have JIS, I can't help him.
I will straighten it out.
Well,
This part is huge, because the judge straight up says the system itself is flawed. When the court admits due process might have been violated, you know we're in rare territory. What do you think? Should bad record keeping ever land someone in custody?
I understand. And Mr. Brown, I appreciate what you're saying. I think it's what has transpired is just crazy regarding JAS. I don't agree with any of it at all. I think certainly to those that have asked, I've expressed that.